Hi, this is Curt and welcome to another edition of Fire Law Roundup.
I don't even know where to start, but let me start. So you can almost hit playback to last week, right? Wasn't it? Was it last week?
We've got three cases, and what we're talking about here is the Kansas City apparatus accident case. But we've got three posts in the last week about this. The case is going like this way and that way and this way, and we wrestled with it a little bit last week. For those who don't follow us regularly, we talked about it last week, and some changes happened during the week, and then this latest one. Brad, take us away on this.
Yeah, here's what happened. So the underlying case is an accident. It's by a firefighter driving an emergency vehicle in clearly a reckless manner, crashes into a car, kills, I think, 3 people, takes down a building. He was then sued, and strange enough, appears without an attorney at this arbitration, but you can think of it like a court, basically. And what I learned here, I guess I didn't know, is that the city had originally said, we're going to provide you with someone to defend you, and then they pull it back. Strange.
And we talked about that last week. We said, like, why would the city do that? That's crazy.
And unbelievable. But we're starting to see a little more of maybe what is a plan come to action, right? Plan come together, in the A-team's words. But here, what happens is, so he's now hit with over 30 million. So I think $32 million the firefighters ordered to pay. Now, I'm just on a flyer here. I'm guessing he does not have $32 million. But
well, he worked a lot of overtime, but
yeah, that ain't going to happen. So he's lost, right? He is now in debt. Presumably there's a judgment entered against him for 32 million. But now what happens is just, I love this. I'll talk about it. I'm so enthralled with this fact. So somebody's very creative, extremely creative, and then we'll give our opinion. So what happens here now, the individual, the driver of the vehicle, says, I should have been entitled to a defense by the municipality. And the local comes in, the union says, we agree, and that the municipality breached the collective bargaining agreement by not representing them. Now, let me throw into here. In this state, there is a limit. So every easy words, right? There's a limit to what a municipality can be ordered to pay. And it's not 32 million. It's 1.8 million, 1.9 million.
I think it's somewhere around 450,000 per plaintiff.
Okay.
And when you add up all the plaintiffs and everything, it comes to 1.8 million.
Not 32 million, right?
Not 32 million.
But this is tort reform. If everyone wonders what tort reform is, it's setting
tort limit, Tort Claims Act, the Tort Claims Act right? Cap.
Yep. Yeah. And not every state, in fact, most states probably don't have it. The federal government has the Federal Tort Claims Act, but most states have not enacted tort reform. It usually starts with doctors, malpractice, and not this. But nonetheless, they're capped per decedent here or injured party at 1.84. So there's still another 30 million outstanding as against the individual driver. So, I had to read this 10 times and be like, what? So the driver and the union have assigned their breach of collective bargaining contract claim, right? I'll explain what that means, to the plaintiffs, meaning what they're saying is, listen, we the union and me, the driver, have a lawsuit, a cause of action for a breach of contract because you violated the CBA's right to representation, defense, indemnity, whatever. And because you didn't provide us a defense, I think this is the breach, then you breached the contract. So they then assigned, meaning gave their lawsuit and said to the plaintiff, you now can stand in our shoes, and if you recover anything, it's yours. This is as creative a lawyering as I've ever seen. I don't know. Why do you start with your You can't make this stuff up, because I have my own thoughts about how this works.
Yeah, I think it's ingenious. And I know when I saw this developing, I'm like, first of all, the city is crazy, absolutely crazy to leave this guy out in the wind.
Right.
And I think, one of the stories we talked about earlier, you talked about scope of employment, and the city is liable when someone does something negligent within the scope of their employment. The city is liable under the respondeat superior doctrine. Okay, so the city's going to be responsible. But if somebody acts outside the scope of their employment, like you mentioned, the park ranger in earlier example, park ranger who's on duty that rapes a woman, they went beyond the scope of their employment. Okay, so I think what happens in a situation like this is somebody gets the bright idea. Well, we're going to argue that he exceeded the scope of his employment by driving in the manner that he did, because our policies say you have to stop at a red light. So he exceeded the scope of employment. And so we're going to try to say he may be liable, go after him, but you can't come after us because he exceeded the scope of his employment. Right. And so that appears to be, and again, I don't know, I don't have any inside knowledge here, but it appears to be the way the city took what happened. So now what happens is they tell the firefighter, we're not going to represent you. He's like, well, what am I going to do? The union files a grievance and said, wait a minute, you've always done this. We have an established past practice. You've always done this. And therefore you need, you're breaching a contract by refusing. And the city, because there's so much, money on the table, they just said, we don't care. We're not going to cover them. So now he says, okay, so now he goes to arbitration. And this is where I was questioning it last week. And they go to arbitration, $32 million. Now the firefighter's on the hook for $32 million. Now he's going to be in bankruptcy. What's he going to do?
Well, and by the way, they can take, I don't know under that state, but under many states, they can take 10, 15% of his monthly wages.
Oh yeah, no question. I mean, but point being, now the city is sitting back going, fine, he's liable for $32 million, and they're looking at the State Tort Claims Act, the STORT Act, State Tort Claims Act, and the State Tort Claims Act says, look, we're at the most we're liable for is 1.8 million. So now we're going to get the city council to authorize 1.8 million, and we're going to settle the claims against the city. And I'm saying, that story broke toward the end of last week. And I'm going, that's what the city was doing. The city was saying, fine, you go do whatever, but we're capped at 1.8 million. Right? And I'm saying, okay, and now I see why the city was doing what they were doing. And I said, that's interesting. Okay, it's almost like a little chess match here, right? So now the next thing that happens is, and I'm assuming that this individual firefighter and the union are working in concert with the plaintiffs. And now they all reach an agreement where the firefighter, Biscari, he assigns 90% of the liability. Now, I've never heard of liability being assigned like this. I've heard of a right to sue, but I guess it is a right to sue. But what you're talking about is $32 million in liability. They assign 90% of that to the plaintiffs in those cases. And so now the three groups, the driver, the union, and the plaintiffs in the case who are owed the $32 million now, file suit against the city saying, you should have represented this guy. You breached the contract, and therefore you have to pay. And the mind-blowing thing about this is that he's accused of negligence. Okay, and negligence has a tort cap. Well, this suit isn't about negligence. This suit is about breach of contract, and Biscari's damages, right? The damage that happened to him because he was not represented was he now has a liability of $32 million. That's his damage. He's alleging that the breach of contract cost me $32 million. Therefore, you owe me $32 million for breach of contract, which is it's not subject to the statutory tort cap.
Except, right.
Holy crap.
So I should hold it up, but I have a drawing. I started drawing this out. So in my mind, maybe the lawyer gives this way more thought, but in my mind, fine. I've said the city breached its agreement by failing to represent me. Now, the question is, what damages arose or could have been prevented by the breach? Here's the amazing thing I'm coming up with. What they're going to have to argue, that the firefighter driver would argue, I would have been able to what? Lower the damages by doing a better defense, a better analysis of what the payroll, job earnings, pain and suffering, all the way we got to 32 million, right? I would have done a better job and would have knocked the number down. Here's, right, so the breach of contract would have been, you owe me what I would have saved had you not breached. Okay, now, if you saw my drawing, that's been assigned to the plaintiffs, who don't want to prove that. That's the funny thing. They don't want to say, yeah, we could have gotten less money if you, right? So if driver, you were represented properly, you would have owed less to us. And we're going to prove you would have, the city would have owed, the city would have owed less to the plaintiffs. How can you assign that case?
Let me make a prediction. I gotta get a crystal ball.
Dismissed.
I don't see a dismissal, but I see a settlement. I see a settlement that it's going to be more than 1.8 million also, but I see a settlement. Otherwise, if they can't, this is going to it's going to have to go to the Missouri Supreme Court, because I think it's a novel issue. I can't imagine this coming up in a different context.
Well, wait a minute. Doesn't this first go to arbitration or whatever the CBA says? This is also on my flowchart. Think about this. You don't go right to court on breach of contract and breach of a CBA. You got to grieve it.
Defense. Yeah, that could be a defense, but yeah.
But wait a minute. Then who appears in front of the arbitrator in whatever process? The plaintiffs?
What's the remedy? What's the remedy? The remedy for the breach?
I just don't see it.
Yeah.
You can't assign away union rights to someone.
What a
I love lawyers.
Something's
lawyers.
cooking on the stove and it doesn't smell good. No.
I think there were better ways to do this, but nonetheless, I love lawyers. I would have, look, it doesn't matter how you end up at damages, right? It doesn't, you could have 10, what we call the law's causes of action. You were negligent, you were reckless, you breached my constitutional rights. Ultimately, each, you only get so much money, but the violations of each aren't the same. So you breach my constitutional rights versus you cause me a personal harm, two separate damages. I'm curious if the better approach would have been to allege something else, like, for example, let's go to Kobe Bryant. People are like, what do you mean Kobe Bryant? Well, the way they got to Kobe Bryant is they said the police department failed to either have a policy or enforce a policy such that I don't know if they use deliberate indifference or not, but such that the city had or the county had a policy of ignoring patients' rights, right? They either had a policy that said don't take pictures, or they didn't have a policy and should have, but were aware they didn't. And so in that regard, we have a whole separate cause of action that's not the personal injury. It might get you to a different number. My question is, I don't think the Tort Claims Act applies to constitutional violations, because I don't think you're not allowed to, as a matter of constitutional law, you can't cap somebody's damages under constitutional rights. It's unconstitutional.
I don't think they alleged there was no constitutional violation alleged.
But that's what I'm saying. Maybe there should have been here to try to, and they still have time. But that's the way I would have gone. This is very creative, but I'm no way.
Yeah.
No way.
Yeah, it's problematic, and I mean, hopefully folks can kind of like just let everything, because I'm sure there's a lot of animosity over this. Let everything settle down, and then get in a room and figure out what the bottom line payment's going to be. Because
and I'll tell you this,
we could be talking about this in 5 to 10 years, because this is going to have to go up and down, back and forth. The issue you raised, I hadn't thought about. Forcing it to go to arbitration, and then what do you do if the arbitrator says the damages are you're going to pay 32 million? Now we're going to have that being appealed, and meanwhile, this case has stayed, and who knows? Who knows? I mean,
and you know, one other thought. So I had said that the plaintiffs can garnish the firefighters' wages. I don't know the state law, but I'm presuming they can.
Yep.
And once you cross the amount that the city's paying, right, which is immediately, they're taking 10, 15% of that firefighter's payroll. If I'm the firefighter, that's the breach of contract. I'm saying, listen, you may be capped at what you had to pay, but you owe me my wages back. A actually different cause of action. When they, fine, I have to pay it, that's capped. Me losing it and having, right, and having it garnished, you know, municipality, you owe me that back. That would have been my claim against them.
That would likely have to go, that would likely have to be grieved.
Yes.
Yeah, you know, so now.
And I wouldn't be assigning that. And the cause of action arises, I think, every time there's a payroll check deduction, it's a continuing harm. So they got all the time in the world, I would imagine. But nonetheless, that's how I would have gone. I love this. This keeps the show interesting, fresh, alive, and you can't make this up.
You can't. This is just so difficult. And, you know, I don't know. I wonder if we'll see other cases like this now that this is sort of
if they win.
There's also, I would, if this was my client, and these folks are not my clients. I've done some work in the past. I've done some training in Kansas City. I know the union president out there and so on. But one concern that I have is collusion. And I don't know how collusion could impact how this whole thing is unfolding. And depending on when an agreement was reached between the plaintiffs and the and Biscari, that would be one concern. And again, I have no idea. I don't know when the conversations happened. If they all happen in the order that it appears, like they didn't have any agreement early, but only after the 32 million was awarded and so on, I think it's on the up and up. But if there was collusion early in this case, and possibly that collusion caused the city, like if the client was kind of doing things that the city didn't want them to do.
Hard to imagine once the city pulls out their defense that they can say anything.
You know, but at any, well, I mean, if Biscari is not cooperating with the city's defense, then the city has got to kind of, you know, what they should have done is get him a different attorney, but you know, not just cut him loose. But I don't know. I guess that's a whole nother issue, whether or not that things were done in a way that there was no improper collusion between the parties. Right. So that's another question mark that's in my mind. But I don't think this is the last time we're going to be talking about this case.
Well, again, clearly not. You know, I do want to make a comment. Every time I lecture, I was just in Maryland the other day lecturing, and I said, you know, we have a hard time educating our officers on the administrative things they need to know. We do a good job on operational. We're not so good on the professional life. And I want to suggest to everybody watching that you would take watching this vlog and bring it to your leadership, because this is law school. And I hate to say it, I mean, it's a high level, but this is direct fire knowledge where we talk about everything, and a lot of things repeat themselves. So it's good learning. You should get credit, I think, for watching our vlog. And I really do encourage the departments out there to try to get training credit, professional responsibility credit by watching this. Yes, there's no test at the end. We can ask you what color shirts Curt and I were wearing or something, but there's no test necessarily. But if you've watched this, maybe write up a 2-sentence, you know, summary of the 4 or 5 cases we cover each time. We're just stealing from Curt's blog, but you know, I think you should get credit, because I think watching something like we offer, to have 2 attorneys with, you know, 40, 50 years of experience between them, giving you this review of cases in the fire service and understanding of constitutional issues, which are, you know, universal pretty much, state issues, best practice issues, policy issues. This should get you some sort of credit for your training. So I hope you will. I encourage you to say that, you know, you want to use this, and this should be true for your lieutenants and captains and upcoming officers. You know, this will provide you good professional education. So I hope you can use it more than just an entertaining sitting around the lunch table and watching us.
Yeah. Agreed. And please, I know I don't say this enough, but please click like and share. Please help us expand our audience, and please subscribe. If you subscribe, the big thing about subscription, and it's free, there's no charge, is that when we go live, YouTube will send you an email so that you can join us, so you'll know. Brad and I both have very busy schedules. I was in Idaho last week when you were in Maryland. And so, we don't always go Monday at 1 o'clock. We like to go every Monday at 1 o'clock, but life gets in the way. So this will give you an email alert that we're going live. So please subscribe. Please help us grow. We want to get up to 1,000 at least. YouTube is going to help us quite a bit once we get to 1,000, but we're closing in on it. We'll eventually get there, but we want to keep doing this, and that would be a big help to us.